To House Bill 99, Representative Ross, if you'll come forward and explain the bill. I have been, I guess I can say that I've been told not to take a vote on this bill today from higher ups, but we do have some distinguished guests here that I did not want to come to the committee without being recognized and heard. Representative Ross, you're recognized to explain your bill.
Well, thank you, Mr. Chairman and members of the committee. This bill came to us from the North Carolina Bar Association's Committee on Constitutional Rights and Responsibilities, and it really is, the whole purpose of this bill is to deal with situations when a vacancy is created in our judiciary right before an election. And the idea would be to not repeat the situations that we've had a few times in the past where a vacancy is created, there's not enough time for a primary. We end up with these really long ballots of people who decide that they want to run with a really short period of time for them to do their campaigning. And then, as we had in the last time this happened in a Court of Appeals race, then result to instant runoff voting in every county of this state in order to deal with that situation. And so that's how it came to us. I agreed to sponsor the bill, and Representative Brine added this additional piece of information about it as his reason for wanting to be a co-sponsor of the bill. And that's that he actually thinks that unless we make this kind of change, given the situation that we've had particularly at the appellate level, because it doesn't make as much of a change for the lower level courts, and I'll explain that in a minute, that sometimes attorneys who have really good, thriving practices will not be willing to take an appointment when there's a short time before the election, essentially close down their practice and take that risk, and then have to run statewide. And so we may, unless we have this kind of change, we may reduce the number of really great candidates who would take an appointment to the bench, you know, close to when they would have to run, for fear that, you know, they would lose a lot of momentum on their practice or have to shut down the practice, because when you do take an appointment to the bench, you can't practice law anymore. And you can't just take a leave of absence and have your name on a whole bunch of cases out there once you've taken the appointment. So basically what this bill would do is say that if there has been a vacancy that's created before the election, that within a certain period of time, that person would just keep that seat for 2 years and then have to run in the next election. That's for the appellate court races. And then we have a separate way of filling of vacancies in state and for the Superior Court and the district court judges, and where it talks about 120 days after the vacancy occurs.
My name is Robert Massengill. I'm here on my own behalf for some legislation I'm working on. But as a private citizen, I have a question and an input. Is this appointment as a result of a death or a legal reason the person is not there?
It can be a resignation also.
Well, I would think the public would not be inclined to accept it if it's for a resignation, but if it was for health or legal reasons. And the reason I say that is there's the inclination there to think that sometimes this might be a setup where, and don't get me wrong, I'm not accusing anybody of doing anything, but you're talking about such a close time frame that would be the end of a term for a person, and then you're going to fill it with an appointee. We would avoid the general election, which you've all pointed out, we all like to have the right to vote on who we want. So my question and thoughts are, is the legal ramifications or the practical or reasonable ramifications for doing it on such a short term? I understand all the complications about moving into an office and doing things or run a business, and most everything you talked about today I really connect with, and this is how I would feel about that as a public person, if you were to propose this, and I had an opportunity to have other input on it, is the reasons we're doing this would not be a setup for something else where somebody decided, well, I'm going to resign and we'll put somebody else in and they're going to run for the next 6 months, a year, 2 years till the next election.
Would the sponsor or any of the backers of this wish to respond to the gentleman?
All I would say, sir, is that that can happen under current law now, just with a different time frame. So, because we would have to then change what would currently be the situation with people who do a resignation. So now we have a, you know, a period of time, but we have people who time their current resignations, you know, for political reasons, so a particular governor could appoint them. So while it might give more time for that to happen, it won't change what our current situation is. And I don't know that we should change what the current situation is, because then we're going to have even more multiple people on the ballot. So what you're saying, I don't know, would make the situation very much better.
Just wanted to inject that thought. Thank you very much.
Are there any questions from the committee? Any discussion from the committee? We'll go ahead and adjourn and put this bill on at some point soon, hopefully. But this exercise was good in that we now have Representative Ross on record saying there are times we need to amend the state constitution.